All right, hello and welcome. Hello and welcome. Welcome to another episode today of the Empowered Immigrant Live. I'm going to move one of my cameras here. Yeah, it's better. All right, we are live, folks. Thank you for being here. My name is Otis Landerholm. I'm the founding attorney here at Landerholm Immigration, A.P.C, where we fight for your American dream. Today, we're live on the Empowered Immigrant Live, and our topic is protecting children through the Child Status Protection Act. So we're going to talk about the Child Status Protection Act, the CSPA, a little bit. I'll share the basics about it. And so welcome. Thank you so much for being here. Remember, the Empowered Immigrant Live is here to train, teach, inspire, and empower immigrants to make the most out of immigration laws and to make the most out of their lives. All right? It's my view that immigrants are awesome. It's my view that immigrants are an enormous contribution to our society or to any society. And we ought to recognize that, folks. We ought to recognize it. And so thank you so much for being here. I really appreciate each of you, whether you're on YouTube, Facebook, LinkedIn, Instagram, TikTok. Today, welcome. Thank you so much for being here with me. All right? Our theme again is how to protect your child through the Child Status Protection Act. And so we'll talk that through. My question as always is, hey, do you want to get a green card? Do you want to apply for asylum or a U visa or figure out some kind of strategy or which option would be the best for you, especially given everything that's going on in the world of immigration law and in the world of politics in the United States right now? Because if so, go for it, all right? And if you are in that situation, I would love to help you in any way that I can with your immigration case. My firm is on a mission to win 10,000 immigration cases in the next 10 years. We would love for your case to be one of them, all right? So thanks for tuning in here to our episode today of the Empowered Immigrant Live. The news, of course, we could talk about the news a little bit. It's May of 2025 is when I'm recording this. Trump has been back in power over 100 days now. There's been a lot of changes, all right? The Laken-Riley Act, the ICE gearing up, starting its mass deportation efforts, the increase in budget for those deportation efforts. The registration requirement has been announced and implemented, and lots of other changes. All right? And so regarding the registration, it's been in effect since April 11th, and the program is being challenged in courts, all right, but it is live right now. Many folks are already registered, like if you've ever gotten a visa or a border crossing card or been in immigration court before or applied for asylum before or applied for really anything where you got fingerprints taken before, then you are already registered. All right, but if you're not, and if you haven't done any of those things, and if you're wondering, should I register, should I not register, do I need to register, etc., my best advice is to get good advice, okay? Get good advice about it. Don't assume that you are or aren't registered. Don't assume that you should or shouldn't register. Don't assume. Get good advice, okay? That's really what I want to share about that. And so similarly, I'll share about the Child Status Protection Act today. So getting to our topic, and as I talk about our topic, if you have questions about your immigration situation, please feel free to send them in, and I'll do my best to answer them here today, okay? So, talking about the Child Status Protection Act, here's the thing, all right? You don't want your child to age out, all right? If it's possible to avoid your child aging out, then we want to avoid that. And let me tell you a story, okay? This week I was meeting with a client where the client husband and wife and one of his children are all here sitting in my office here in the United States. All of them have green cards. But their other son is back in their home country, not with a green card. Why? Because he aged out. Okay? And so like that concept, it divides families. All right? And there are people that come in for consultations too late because one of their children is no longer considered a child as defined by the Immigration Nationality Act because unfortunately they aged out. Okay, does that make sense? That is sad, folks. It's sad. And you got to understand how the system works. The word child in immigration law means two things. It means a person is, one, unmarried, and two, under 21. All right? Which means if you're applying as a family, you got to make sure your child remains unmarried and under 21. And when I say under 21, I put quotation marks around it because of a thing called the Child Status Protection Act. Okay? So what's the Child Status Protection Act? This is a law. It was passed in 2002, all right? None of this is new. This is old stuff, but I wanted to share about it because it affects cases even today. Okay? What the Child Status Protection Act says is that if you're a U.S. citizen filing for a child who's underage, file that petition before your child turns 21, they're an immediate relative, and boom, when you file that petition, they're locked in. Okay? So if you're a U.S. citizen and maybe you just won your citizenship, you just naturalized, and you have a child that's 20, get that petition on file quickly, all right, before they turn 21, and their age will be locked in. The Child Status Protection Act protects the status of a child even if they turn 22 or 23 or 25 even before their green card's approved. Their status as a child will be protected as long as you file the petition before they turn 21. Got it? For citizens, for citizen parents. But if you're an LPR parent, all right, or if you're applying to become an LPR, a lawful permanent resident, a green card holder, all right, LPR and green card holder are synonyms. This is the same thing. You're a lawful permanent resident. If you're a lawful permanent resident and you file your petition, then there's a formula that is entered into by the Child Status Protection Act. And the way it works is you get to add the number of days that the petition was pending to the child's age. Okay? Say that again, lawyer. Say that again. Yeah, you get to add the number of days that the petition was pending to your child's age. So imagine that your petition was pending for 100 days, all right? And imagine that as your child's going through the process, they turn 21. And imagine that they're going to their appointment and they're 21 and 75 days. Okay, so now they're protected by the Child Status Protection Act because the petition was pending for 100 days, and they're still a child even though they're over 21 for that extra kind of buffer of time, depending on how long the petition was pending in your case. Okay? So we got to do the math, and we got to figure out whether or not your child can be protected by the CSPA, by the Child Status Protection Act. Bottom line is, if you are eligible to file a case for your children, it's wise to do it as quickly as possible so that nobody ages out. Okay? That's really what I wanted to share today. And the best advice, as always, is to get good advice. The best advice that I can give to you is to get good advice about your situation and how to maximize your family's chances of success and of successfully navigating the immigration process. Okay? So that's what I got to say today. Thank you so much for being here. Thank you for being here with me. My name is Otis Landerholm. I'm the founding attorney here at Landerholm Immigration A.P.C., where we fight for your American dream. And let's get into your questions. I do have some time to answer some questions today, so I'll do my best here. Please feel free to submit them. So my first question today comes from Sony. All right, Sony, thank you for being here. You say, I applied for my brother and sister in October of 2009. How long I got a welcome letter from Pakistan? Okay, let's look. So we've got to look where there's a sibling petition or any other petition that's managed by the Visa Bulletin. We've got to start with the Visa Bulletin for the current month. So right now, May 2005. I'll pull up the Visa Bulletin here. Let's see what it says. So right now, fourth preference category, category F4 from Pakistan, says that they're adjudicating cases, finalizing cases for families, for brothers and sisters of U.S. citizens that were filed on or before the 1st of January of 2008. All right? So if your case, Sony, was from October of 2009, then you still have, they're not on to 2009 yet. Right now they're just starting 2008. So you still have like a year and 9 months worth of priority dates for the government to get through. And remember, the category F4, the government only reviews 65,000 of those cases in that category each year. And so there's a backlog, right? There's a backlog that's very, very long, so it's a very slow-moving category, but that's where you're at, all right? And so how long to get a welcome letter, it's impossible to be able to predict that for sure, but at the very least, it'll be another year and 8 months, right? Another year and 10 months, because from January 2008 to October 2009. But my guess is it'll probably, in practice, be more like 3, 4, 5 more years because of how long those categories take. Okay? All right, so let's see. Hi, DVE. I see your question here. You say, what if the petition was filed before they turned 21, but it got denied, and now they're over 21? We got to look at, well, first of all, we got to see, was it denied correctly? Because you might need to appeal the denial, but an appeal, you got 30 days to do that. And so double check when the denial happened, and if it happened recently, talk to a lawyer right away. And if it has long since been denied, then you might need to refile. If a petition was denied, then it doesn't protect a person. Okay? And so, that's another reason to start a case well and get good legal advice from the beginning so that you maximize your chances of getting it approved. Okay? So very good. Let's see, Emmy Khalil, I see your question here. Received a notice of transfer of my case in March, and again I received another notice of transfer yesterday. How many times will one case receive notice of transfers, and what does it mean? Thank you, Emmy, for asking this question. What does it mean? Perhaps it means that the government is less organized than they ought to be, all right? Perhaps. In a smooth process, your case would never be transferred, or it might be transferred once from the service center to the field office. All right, but it's often the case that things change, or the government will say, okay, this service center is receiving too many cases right now of this case type, so we're going to transfer this type of case from this service center to a different place where they can handle, they have more availability to handle this type of case, etc. Or sometimes that it'll just be there temporarily before being sent to your local field office to handle an interview. For example, sometimes we see it where after a more recent notice of transfer, we get scheduled for an interview, And so the thing to ask, Emmy, is where did it get transferred to most recently? Because if it was transferred to the field office, then maybe that indicates that your case will be scheduled for an interview soon, right? Or in the somewhat near future. Anyway, if you want to look at your case in much more specifics or get a second opinion or make sure everything was done properly, feel free to reach out. We'd be happy to help. Okay? Maria Lacerda, thank you for being here. You say, good morning. I've been waiting for my work permit for almost 3 months under the U visa. What should I do? What is my next step? Gracias. Gracias a usted. Thank you so much for being here. Really appreciate you. And so, to be honest, 3 months of a delay on a work permit under the U visa is very common, right? It's like nothing to worry about. You get to 9 months of a delay, and maybe we should have a conversation. But 3 months, you're doing good. Okay, you're doing good. And so I would say hold tight, be patient. Feel free to reach out or talk to your attorney if there is any red flag on your end or anything that seems out of the ordinary. You can always call, your attorney and just say, hey, are we still within normal processing times on this type of case? In our office, we have a great team of case managers who can look that up. It doesn't, no additional cost for our clients, right? We build that in. And so, and so that's what I would say. Although in my experience, 3 months waiting for a work permit is, it's very common that a work permit will take slightly longer than that. All right, baby boy, I see your question here. Do you do removal proceedings? Yeah, like all day, every day. Yes, absolutely, we do removal proceedings. And if you have a case in immigration court, we're here to help. We'd love to help. Okay? Feel free to reach out. Let's see. Hi DVE. I see your question here as well. Are immigration cases getting referred to court if it gets denied? Yes, they are. Is every case being sent to immigration court if it gets denied? We're moving in that direction, but it's not my experience that every single case that gets denied goes to immigration court. It depends on the process, and it depends on a person's individual immigration status, all right? For example, if a citizenship case gets denied, that doesn't mean that a person is quote-unquote deportable. And so, but what you have to keep in mind is if a person is being denied their immigration status and they have no other status, then they very likely will be sent to immigration court and put into deportation proceedings. All right? Let's see. Mi Mexicana uno. Yeah, thank you. Thank you for being here. You say, do you still have to do the bar to be an immigration attorney? Yes, you do. Yeah, to be any type of attorney, you have to pass a bar exam. You have to be admitted as an attorney. Yep, typically. I sneezed. Sorry about that. So typically, you have to do law school for 3 years, and then you take the bar exam, and then you do the good moral character requirements that your bar requires, and then you can be sworn in to become an attorney. Okay? All right. Excuse me. Okay. So, and then hi DVE, I see your question again. You say, can you refile a green card case by a different sponsor if you have a motion to reopen or a motion to reconsider pending. Talk to a lawyer. My best advice, talk to your lawyer, really think that through, because yes, you can file a different green card case through a different sponsor or a different petitioner. You can do that, but is it wise to do that? Those are two very different questions. And so I would say talk to your lawyer, really think through the strategy in your case, and talk about whether or not it's worth it to do that. How strong are your likelihood of success? Is your likelihood of success on your motion to reopen or reconsider, and then go forward from there. All right, good question though. Emmy Cahill, you say it was transferred to the Vermont Service Center for processing. Okay, all right, and so it's still at the service center, so it's not likely then that they would schedule you for an interview anytime soon. But maybe, depending on what type of application it was, maybe they can make the decision on your case. All right? So just because it's transferred, though, doesn't mean that it goes straight to the desk of a new officer, right? Just so that you're aware, right? These service centers are very large, and each one has, more than 1,000 employees. And so, they will put it in a giant stack basically put it in the queue, ready to be adjudicated and ready to be assigned to an officer to review and issue a decision on. But it might still take several months, in other words, Amy, just so I'm speaking clearly. All right, what other questions are out there? Let's see. I'll take a couple more, and then we'll wrap up for the day. Let's see. I see a question here. My stepdad filed for us a while ago, and it was denied because of the lawyer, but my mom is naturalizing. Okay. And so, hi DVE, I see that question there. Your stepdad filed for us a while ago, and it was denied because of the lawyer. Got it. But my mom was naturalizing. The thing to explore there, yes, lawyers make mistakes, all right? And yes, there are bad immigration lawyers out there, so be mindful and be cognizant of that. But it's also wise to really review your decision, all right? Like, does the USCIS decision say, we are denying your case because of your lawyer? I don't think so. Like, you really want to look at your decision and be like, okay, why really was it denied? And maybe it's true that the lawyer didn't prepare the case very well, and maybe the USCIS's reason is, oh, we're denying your case because there wasn't enough evidence included with your case, or something, or it was improperly filed, or something, and you could perhaps directly point that to the lawyer. But my guess is that there might be some other reason that USCIS denied that case, and you want to be clear about what they're saying, right? And if you're not clear at all, feel free to reach out, right? We could do a consultation and really look at that and talk that through, and now how could we fix it? And I'm glad that your mom is naturalizing. I hope she has a good lawyer so that she can win her citizenship, and then I hope that changes the situation for you. So good. All right, I see a question here. Let's do it no risk. All right, cool. So, cool name. You say, I have a denied N400 for misrepresentation on my green card application. Will it affect my green card? What should I do? Yeah, that can, all right? So misrepresentation on your green card application means that technically you are, quote unquote, deportable if the government alleges that you were deportable, all right? And to allege that, they would need to give you what's called a notice to appear in immigration court. And there are options for people in that situation. I have taken cases like that and won cases like that. And so check out a waiver that's called the 237A1H waiver. That exists as a waiver for misrepresentation in your context. Along with things like LPR cancellation, along with asylum, along with VAWA cases, there's lots of different possible solutions to your situation, and you would want to talk those through with your lawyer. And if you don't have one, feel free to reach out. I'd love to help you. Okay? All right. Emmy, I see what you're saying. It's a VAWA case. Okay, yes. Common that a VAWA case would be transferred to the Vermont Service Center. They are the experts in U visas, T visas, and VAWA cases. All right? So very good. Very good. Okay, you guys, well, thank you all so much for being here. I really appreciate each of you for joining me right now. And, what can I say about life for you? Take things one day at a time. Be present as we are. Don't let worry and fear and doubt and all the craziness that we see in the news every day, don't allow those things to affect your own personal, physical, mental well-being in the moment. All right, like we can be good people, we can contribute the way we can, irrespective of what happens on the 10 o'clock news on any given day, right? And so let's do that. Let's be mindful of our own thoughts, our own feelings, our own actions, and how we treat each other, because ultimately those things are what make our lives what gives our lives the contribution that we intend to give them. Okay? And so I want to share that. I hope that's useful. I hope that's helpful. In other words, feel free to turn off the news, unless turning off the news causes anxiety or stress, which sometimes that happens. But feel free to really put the news in one place and think about, okay, what do I want to do and how do I want to be today with the people around me? And I encourage us to always have some perspective in that. Anyway, I hope that's useful. Thank you all so much for being here. I really appreciate each and every one of you. My name's Otis Landerholm. I'm the founding attorney here at Landerholm Immigration, A.P.C., where we fight for your American dream. If this was useful, please take a moment and subscribe to our channel in YouTube. All right, we're going for 20,000 subscribers on our channel in YouTube, and it would mean a lot to me if you joined us and subscribed to our channel. When you do that, if you hit the notification bell, you can receive a notification whenever we upload an additional video with news, with updates, with changes in the law, things of that nature, so that you can stay in communication and stay informed. And if you have an immigration case, or if you know someone that has an immigration case, please feel free to reach out. We are here to help, and we would love to help. All right? Thanks a lot, everybody. Make it a great day. I'm Otis Landerholm, Landerholm Immigration A.P.C., where we fight for your American dream, and I'll see you next time on our next episode of the Empowered Immigrant Live. Thanks a lot. Make it a great day. Take care. Bye-bye.